of the liberties are contained in the incredibly unhelpfully named Bill of Rights, which isn't even called that in the Constitution. It's just the name we give to the first 10 amendments. The 9th Amendment is included to remind us that the list of liberties and/or rights in the other amendments isn't exhaustive. There might be other rights out there, but the Constitution doesn't specifically say what they are. Thanks, Constitution. In some cases, it's pretty clear. The First Amendment, for example, says that Congress shall make no law respecting the establishment of religion or abridging the free exercise thereof, or abridging the freedom of speech or of the press, or to assemble or to infringe the right to petition the government for redress of grievances. Pretty straightforward. But other cases are not so clear. The Second Amendment says the right to keep and bear arms shall not be infringed, but it doesn't say by whom. Same thing with the Fifth Amendment guarantees against self-incrimination. Could Congress force you to incriminate yourself? How would they do that? And the Eighth Amendment prohibits cruel and unusual punishments, like presumably shock pens. But it doesn't say who is forbidden from cruelly and unusually punishing. My mom wasn't forbidden from keeping me from playing video games. So the Constitution deals with religion right there in the First Amendment, which is also the one that deals with speech and the press and assembly and petitions. Here's what it says. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. It's the first clause in the First Amendment of the Bill of Rights, so it's pretty darn important. Notice it has two parts, and each one creates a separate religious liberty or freedom. The first part, no law respecting an establishment of religion, is called the Establishment Clause. Can you guess what the second religious liberty is? If you said free exercise, you're right. What do these two freedoms mean, though? Establishment of religion means that the U.S. can't create an official state church, like England has with the Church of England. This means that the First Amendment ensures that the U.S. does not have any state-endorsed religion, nor does it write its laws based on any religious edicts. And it's also the clause in the Constitution that deals with religious monuments and school prayers and stuff like that. The Free Exercise Clause, in a way, is more straightforward. It means you can't pay for exercise. Gym memberships are illegal. But freedom isn't free. You're going to pay with pain. No pain, no gain. Actually, none of that is what we're talking about. What it means is you can't be prohibited from being part of a certain religion, although it doesn't mean that any religious practice is okay. There are two really important things to remember about the First Amendment protection of free speech. The primary reason to have freedom of speech is to allow for public criticism of the stupid government. Stupid government. That's the sort of thing that can land you in jail in countries that don't have strong free speech protections. Or should I say, you would be Putin jail. Don't put me in jail. Oh, that's right, I'm in the U.S., it doesn't matter. The stories of oversensitive kings and dictators silencing people who question their rule or even make jokes at their expense are too numerous to recount. But for the most part, that kind of thing doesn't happen in the U.S., which is why no one gets arrested for carrying around a giant picture of Obama as Hitler, or former President Bush as a monkey. Well, that stuff's okay as far as the First Amendment is concerned, but that doesn't mean it's respectful or in good taste. The main thing to know about the First Amendment and the press is that it prevents the government from censoring the press. For the most part, this means preventing the press from publishing some information in the first place, although it can also mean punishing a news agency after they publish something. Let's deal with pre-publication freedom of the press first. Let's go to the thought bubble. Censorship of the press before a story is published in print, broadcast, on television, radio, or the internet is called prior restraint, and the Supreme Court ruled that it was not allowed in a case called Neer versus Minnesota. In that case, a newspaper called the Saturday Press was going to publish a story that the city of Minneapolis was under the secret control of a cadre of Jewish gangsters, in particular the mayor and chief of police. City officials obtained an injunction to stop the publication of the story, and they gave the Saturday Press editors the opportunity to go before a judge to prove that the story was true. I'll get to this question of truth in a minute. The judge ordered the injunction and said that if the newspaper violated it, they would be punished for contempt of court. Instead, the newspaper countersued, claiming that Minneapolis and Minnesota were violating their freedom of the press. The Supreme Court agreed that no government was allowed to censor the press because a free press is essential for the political system to work. They based their decision on a lot of history, including Blackstone, the British legal authority, which explained, "The liberty of the press is indeed essential to the nature of a free state, but this consists in laying no previous restraints upon publications, and not in freedom from censure from criminal matter when published." And they also relied on an important American authority on the Constitution, James Madison. Heard of him? Who derived a lot of his constitutional expertise from the fact that he wrote the thing. He said, "This security of the freedom of the press requires that it should be exempt not only from previous restraint by the executive as in Great Britain, but from legislative restraint also. Citizens need a free press to be able to criticize the government and to expose government wrongdoing, because otherwise the government can get away with all sorts of things that we don't want it to, like say spying on us and reading our email and reading our spy's email. Of course, even with a free press, the government can do this, and what constitutes the press in the age of the internet is a debatable question. WikiLeaks, anyone? But the basic proposition that the press must be able to protect us against an overreaching government still stands." Thanks, Thought Bubble. There's another reason why the court put the kibosh on prior restraint, and that's because if a newspaper prints something that is untrue about the government, or more practically about a government official, there's a remedy for this. The person or agency about whom the untrue thing was said or written and published can sue the publisher for libel, and if he proves his case, can get monetary damages. As you can see, the First Amendment offers a lot of protections to citizens in the press, especially when they're criticizing the government or its policies, or even when they're making fun of celebrities. And this is really, really important because American democracy relies on its citizens having enough information to make good decisions and hold elected officials accountable. We rely on the press to tell us what the government is doing so that we can decide whether or not we want to let them keep doing it. If the government can keep us from getting important or even not so important information by censoring the press or by preventing us from speaking out against what we see as wrong, it will be able to keep doing things that might be bad. And this is the kind of tyranny that the framers of the Bill of Rights were most worried about. So the more you're concerned about tyranny, the freer you want speech in the press to be. This is something to think about when you engage in arguments about Edward Snowden and his NSA disclosures, or Julian Assange and WikiLeaks. Criminal procedure civil liberties are found in the 4th, 5th, and 6th Amendments, but today we're only going to look at the 4th Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." You can see right away that this is not an absolute right. The framers made sure that we are only protected from unreasonable searches and seizures, and they added that the police are supposed to get a warrant before they search you. According to the 4th Amendment, for the police to get a judge to issue a warrant, they must have probable cause, which is more than just a suspicion or an anonymous tip, although sometimes judges will issue warrants on pretty flimsy probable cause. When they are issued, warrants are supposed to be specific, laying out what the police are searching for and where they expect to find it. This means that if the warrant says the police can search your garage for a stolen car, they can't look in your kitchen drawers and cupboards because A, the warrant says they can search your garage, and B, they're looking for a car, and you can't hide a car in your kitchen drawers. Police stop you for speeding, which is a violation of traffic laws, also known as a crime, and then search your car and find a dead body in the trunk. The courts have ruled that this is reasonable too. It's important to realize that the warrant and reasonableness requirements are not meant to prevent the police from stopping criminals caught in the act. If the police, after chasing a masked man carrying a bag with a dollar sign on it, running away from a bank that has just been reported robbed by a man with a gun and a mask, manage to catch him, they don't need an arrest warrant to take him into custody. And because the running away and the bag of money are pretty suggestive, the police will have probable cause to search the guy, who in my mind looks like the Hamburglar, for the gun. Students often think that it's not okay for school officials to search their lockers or their book bags, but those students are wrong. Most students go to public schools where the officials are mostly government workers and are subject to the Bill of Rights. The courts have ruled that students don't have the same protections as other citizens, and that the interests of the state in keeping a safe, drug, and weapon-free educational environment trumps their privacy interests. Although there are limits to how intrusive these searches can be. Drug tests for student athletes? Fine. Strip searches? Not okay. And BT dubs, in the same way that a breathalyzer test is a search, so is a drug test, or as they say in England, a drugs test, which is probably a more accurate way to say it because they usually test more than one drug. These can seem pretty intrusive, but the courts usually rule that they are okay, especially where public safety is concerned. The state interest in drug-free schools is a pretty strong one, but the cases on student drug tests are really interesting, especially when they get into the issue of whether schools can test all students without probable cause, or only specific groups like athletes. If you're really interested, you should look these cases up. But why are you so interested? Maybe you should take a drug test. Or a drugs test. So I'm going to stop here before I get too deep in the weeds about search and seizures and the 4th Amendment. There are two important things to remember. The first is that, like all the constitutional protections of civil liberties, it only applies to government agents. You have no 4th Amendment protection against your parents searching your room. Unless your parents are police officers, and they're on duty, and it's like official police business. The second thing to remember is that the protections in the 4th Amendment are far from absolute. The amendment itself includes a reasonableness standard, and what is reasonable, as well as when warrants are necessary, has been and continues to be determined by the courts. In this case, as with most civil liberties cases, the courts attempt to balance an individual's interest in maintaining her privacy against the state's interest in preventing crime and keeping citizens safe. It's not an easy balance, but that's what makes the issue complex and interesting.